The streamlined domestic and foreign offshore programs allows U.S. persons living inside as well as outside the U.S. to avoid criminal charges and the excessive FBAR penalties, but only if you can prove that you are non-willful. The penalty is only 5% of the highest foreign bank account balance and foreign financial asset in the last 6 years. This tax law firm will prove, with substantive evidence, that your conduct was non-willful. We will collect the documents and evidence, as well as testimony from witnesses, to prove that your failure to file an FBAR, or the unreported foreign income, is a result of mere negligence, inadvertence, or mistake, or that you had a good faith misunderstanding of the law. We'll write a detailed explanation of the facts, written in a light most favorable to you, and certify that your actions were non-willful. The streamlined domestic procedures do not apply to delinquent income tax returns or if you're currently being audited or under criminal investigation. We will amend your last 3 years' income tax returns and file the last 6 years' FBARs. Compute the 5% penalty based on only the unreported foreign financial assets. We will assure that there will be no double accounting for funds transferred between foreign bank accounts, and ensure the proceeds from the sale of real property deposited in your foreign bank account are not double accounted for. We will competently prepare the 114 FBAR, the Form 8938, which reports foreign financial assets, 3520 trust and gift forms, 5471 corporate forms, as well as 926 and 8621 forms. We will be well prepared to prove that the failure to comply with the technical aspects of filing every particular form and reporting every foreign financial asset was not willful. For taxpayers residing outside the United States, we will file your delinquent and amended income tax returns, 6 years of FBARs, and prove that you comply with the non-residency requirement, which is living outside the United States for at least 330 days for 1 out of the last 3 years. We will research the foreign treatises to see if your income from your foreign retirement or savings plan is tax deferred in the U.S. as well as in your own home country. There is no penalty for the streamlined foreign procedures. This tax law firm has been doing voluntary disclosures since the 1990s, before they were popular. We have competently represented hundreds of clients in traditional voluntary disclosures, the 2009 voluntary disclosure which applied a 20% penalty, the 2011 Offshore Voluntary Disclosure Initiative, which is a 25% penalty for 8 years, the 2012 Offshore Voluntary Disclosure Program, which is a 27.5% penalty, the 2014 OVDP, and now the Streamlined Domestic Offshore Program and the Streamlined Foreign Offshore Program. The IRS and DOJ is actively pursuing many taxpayers criminally for their failure to file FBARs, failure to report foreign income, and failure to file information returns. This is a potential criminal case that needs to be handled by a competent tax attorney with the benefits of attorney-client privilege, not by a CPA, enrolled agent, tax preparer, or other unlicensed individual. All information you provide to your CPA, enrolled agent, or tax preparer must be disclosed to the IRS, otherwise they'll lose their license to practice. They're not an attorney. Our attorney's fees are reasonable. I have my clients collect and organize documents and prepare a memorandum of tax issues, all of which significantly reduce the attorney's fees. I keep the attorney's fees as low as reasonably possible, as I want long-term happy clients. We are some of the most competent and aggressive tax attorneys when it comes to assuring you pay the lowest tax, penalties, and interest allowed by law. Please call me at 858-481-4844, and I'd be happy to talk about your tax case. The communication is protected by the attorney-client privilege and will not be disclosed to the IRS under any circumstances. I look forward to hearing from you.